Ooh, that's not good. There we go. My name is Judge Tangela Bear. I'm the judge for Division 10. So we are here to finish closing arguments. Let me move that one back up. Hillary Fowler versus Walter Gibson. I see both the parties present. For Ms. Fowler, Ms. Hinkson is present, I see, and for Mr. Gibson would be Ms. Tyler, and I see her as well. Okay, so it looks like we have everyone. Looks like we have a court reporter, everyone participating in the takedown.
Good morning. That's correct, Your Honor.
All right, Ms. Tyler, is that is that correct?
Yes, Judge, that's correct.
All right, then let's go ahead and get started.
And I can start with the closing, Your Honor. I'll start with my.
Yes.
Your Honor, so we are here today as my client filed a modification for child custody visitation and child support on October 27th of 2022, and the respondent filed an answer. I believe the evidence that was presented at the January 22nd, 2024 hearing supports my client's request for modification. So the parties have consented to my client being the one to be the sole custodians relating to passport execution, so applications and renewals. The parties, my understanding, also have a consent with my client being the one to cover the minor children for healthcare coverage. So she would be covering them on her healthcare insurance. The other agreement that the parties have was based on, in May of 2023, there was a consent parenting plan order, which was my petitioner's 3, Your Honor, that the parties consented to in regards to visitation, parenting time, and those matters. And so those are the areas that it's my understanding there is an agreement on, Your Honor.
Okay.
Okay. The areas that I believe that there's a disagreement, and I believe the evidence provided in support of my client's request is the follows, Your Honor. I believe the evidence from January 22nd of 2024 shows, Your Honor, that Mr. Gibson does not know his children, does not have any intentions of knowing his children, and has not exercised any meaningful or substantial visitation with his children since the original order in 2019. I believe the evidence that was presented and based on his testimony shows that in the last 5 years since the first original parenting plan order, that Mr. Gibson has only exercised 8 visitations, and those 8 visitations took place within my client's home, Your Honor. I believe that the evidence that was presented, Your Honor, also shows that Mr. Gibson stated to the court very bluntly that he was not going to be exercising any visits for the imminent future based on what he was alleging, I believe at that time, to be some threats or concerns that he had relating to my client. However, no evidence, no pleadings, no testimony, no tangible evidence, nothing was provided to support his assertion that his reasons for not visiting the children were valid in regards to any accusations. I believe Your Honor even asked him specifically, if you had these concerns since 2019, what did you do in order to remedy those? And Mr. Gibson's response was, I quote, "No one asked me about those things." And so again, since 2019, I believe the evidence also shows that Mr. Gibson was never going to be exercising any of his parenting plans. If you recall, Your Honor, the parties executed the document on June 6th, I believe, of 2019, and by June 30th, 26 days later, Mr. Gibson had moved out of state to Missouri, although the parents had an in-state parenting plan. I believe the evidence shows that based on the consent of the parties, that Mr. Gibson was supposed to be exercising quarterly visits. So going from bi-weekly visitations to 4 visits per year, and that Mr. Gibson, since the execution or agreement of the 2023 change, has not opted into any of those visitation plans, and in fact has provided my client with notification that he was not going to be opting into the first 2 quarters of that plan. And so I believe what's truly disheartening about all this is that if we're to believe that Mr. Gibson is in fact unemployed, there would be no reason that would have been prohibiting his ability to have meaningful visitation with these children or exercising some of the parenting plan, especially since he wants the court to believe that he's an independent contractor, Your Honor. And so I do believe that the evidence would support that Mr. Gibson has failed to exercise any meaningful, substantial parenting time relating to this matter. I believe, Your Honor, the evidence also showed that Mr. Gibson's income should be imputed. I believe that Mr. Gibson has what we and my client is requesting is a high income deviation. I believe that he's alleging to only make, or testimony in his DRFA stated that he only makes $631 on a monthly basis, Your Honor, which I don't believe is true. Your Honor, in Hendry versus Hendry 734 SE 2D 46, Georgia 2012, the court held, for the purposes of child support, gross income includes all income. Your Honor, pursuant to OCGA 19615, subsection F1A, they give the definition of what attributable income is as far as gross income for each parent. And there's a list of what those incomes are: salaries, commissions, self-employment, bonuses, dividends, trust, all those different things, Your Honor. And I believe that what the evidence showed is that Mr. Gibson does in fact have more attributable income than he is actually alleging to have, Your Honor. I believe the evidence showed, based on Mr. Gibson's tax returns, that in 2020, he made $418,191. In 2021, he made $945,455. In 2022, he made $1.2,572, Your Honor. And if we are alleged to believe what he's made roughly over $300,000 from what he's mentioning for 2021, which 2023, which if you included again, all of his attributable income, Your Honor, still comes closer to over $1 million. I believe that, again, based on that, and again, based on OCGA 19615 subsection F4A, that the court can consider imputing Mr. Gibson's income and should consider imputing Mr. Gibson's income. I think some of the factors that the court has to consider when looking at that specific imputation of his income is, again, also specific factors. So in this particular case, does Mr. Gibson has assets? He does, over $1 million. Is Mr. Gibson his residence? Mr. Gibson is living in an apartment that's over $3,300. Employment and earning history. Mr. Gibson testified that he has over 20 years of experience at his employment, and I believe testified that at no point was he out of employment outside of coincidentally this proceedings, Your Honor, for more than 6 months. I believe that you also look at his skills, his education, which he's highly educated. He mentioned having several degrees. And then you also look at his lifestyle, Your Honor. And those are just the factors as far as imputing his income. I do believe that OCGA 19615 subsection 4 F4D, Your Honor, is that Mr. Gibson is intentionally and willfully underemployed at this time. And I do believe that that is voluntary, Your Honor. Mr. Gibson did not provide any evidence in regards to outside of, I believe he mentioned some LinkedIn requests that he made. But again, when asked if he was aware that those things on his LinkedIn had mentioned that he was still employed with his previous employer, he was unaware of that. Mr. Gibson didn't provide any documentation outside of, I believe, some snapshots of his attempts to seek employment. However, Your Honor, what I do believe that when you also are looking based on that statute for willful underemployment is, again, several different factors in regards to that. Specifically, it looks at whether or not Mr. Gibson is a caretaker, whether he has other children, what type of lifestyle that Mr. Gibson has. Mr. Gibson testified that he's caretaker of no one but himself. Mr. Gibson has provided information about his lifestyle, specifically his DRFA. Mr. Gibson has not one, but two cars. He has a Jeep that he paid $38,000 in cash for, a Audi that he spent $107,000 in cash for, and why he wants the court to believe that he only makes $631,000, Your Honor. All of his DRFAs that he provided since the commencement of this case is no less than $13,000 in monthly expenses. And so respectfully, Your Honor, the math is not mathing if he's only making $631, how he has $13,000 in expenses. He spends and has the ability to have vacations. He has the ability to provide gifts. Incidentally, none of those gifts for his children, Your Honor. He has the ability to provide maintenance for himself, Your Honor. And so this is not a man, respectfully, that does not have the means or the capability of taking care of his children. Your Honor, I also believe that based on the evidence that was presented at that last court hearing relating to this matter, Your Honor, is that specifically pursuant to OCGA 19615, lowercase I, 2A, it says what the court can consider when determining high income deviation. And that is a combined income of the parties, Your Honor, of $30,000. In this particular case, Your Honor, my client has a base salary of $16,733. And we believe that Mr. Gibson has a base salary of close to $85,000, Your Honor, when you consider all of his income combined. So they both combined exceeds that, Your Honor, and have a combined gross income of $101,889.36, with Mr. Gibson having double of that, Your Honor, relating to what we believe is his attributable income. And so because of that, Your Honor, we do believe that the high income deviation can be applied relating to that. Based on that and the worksheet that I provided, I believe that Mr. Gibson's new child support number should be $4,794, Your Honor. And that is what my client, $4,794, Your Honor. And Your Honor, that is also supported by Fladner v. Fladner 765 S.E.2D 354 2014.
Okay.
I believe that based on the evidence, Your Honor, what was also presented was the special education needs for the children, and that was pursuant to OCGA 1916, subsection I, 2J, lowercase I, and Your Honor, that was under extraordinary educational expenses. I believe that there was testimony provided by Ms. Joanne Flackenstein, who is the one of the minor children's occupational therapists, and she provided a plethora of information on why it was important based on the findings of not only previous assessments and evaluations, but also her personal knowledge, observations, and communications with the other child's occupational therapist, that why a specialized school is required and necessary in order for these children to thrive. She also specifically stated that she believed that if there was not these accommodations taken into place, that there could be a regression relating to the children as far as their educational component. There was also testimony from Mr. Gibson, specifically in him stating that he was aware that this is not an isolated incident. This is not something that my client is intentionally getting different evaluations or assessments about, but that specifically he was physically provided with all of the evaluations, all of the recommendations, and has had the opportunity to follow up with anyone that he needed to, and also agreed to pay for the school that they are currently in based on their needs. I believe when we were here the last time, Your Honor, he stated that although he was not contesting that they had special needs when Your Honor inquired into that, he just wanted to be able to figure out if there was more public school options. When again, further probed on what public school options he was inquiring to, Mr. Gibson said he needed to find out schools about DeKalb, and not respectfully even aware that that's not even a county where the children lived in, or at least not the pronunciation of the county that the children lived in. And so Mr. Gibson has done no due diligence on trying to figure out any educational components relating to these children. And my client, who has spent hours and years and has a historical aspect of making sure that she meets the needs of her children, Your Honor, has continuously provided Mr. Gibson with this information. And Mr. Gibson is aware that his children has extraordinary educational needs that were also provided in tangible evidence and through testimony, Your Honor, of not only Ms. Flankenstein, my client, but also confirmation from Mr. Gibson of his knowledge of their needs. There was also evidence, Your Honor, and so because of that, my client is specifically requesting that he pays 65% of the private school expenses, Your Honor, relating to the children and their needs. Again, pursuant to OCGA 19615KI, Your Honor, and OCGA 19615, my client is asking for child care expenses. Again, I believe there was plethora of testimony relating to this matter on how Mr. Gibson is not intending to exercise his parental parenting time relating to this matter, and that he has no intentions of doing so. And so my client is requesting not only that he pays for 65% of her and the work-related, but also regular childcare expenses, Your Honor, and not to exceed $1,600 per month for the children. My client is also, Your Honor, requesting that Mr. Gibson pay 65%.
Let me back. So the additional childcare expenses of $1,600 a month, is that something you're saying that's in the child support worksheet that ends up with the 4,700, or is this outside of the worksheet?
This is outside of the worksheet, Your Honor.
Okay.
And it's based on my client's need for additional childcare expenses, Your Honor, and care for her work, but also on weekends and different things like that for the holidays and summers. My client is also requesting, Your Honor, a 65-35 split of uncovered medical, dental, and other expenses, with Mr. Gibson paying 65% of that, and my client, of course, having the 35%, Your Honor, relating to that matter. And the last thing that my client is requesting is attorney's fees, Your Honor, and that is pursuant to OCGA 19615K, subsection K, and OCGA 19-9-3, subsection G. Your Honor, it's very specific in those statutes that it says that if the upward modification of child support is due to the failure of a party to be available and willing to exercise a court-ordered visitation and parenting time, that attorney's fees can be ordered, Your Honor. It also states that, again, based on OCGA 1993, subsection G, that the court has a discretion to award attorney's fees. Your Honor, I have been in this area of law for more than 10 years. I am competent. I'm over the age of 18. I've been a member in good standing in the state bar since 2013. I've been in the area of family law as in practice since for the last 10 years. However, I've been in the area of family law since 2009. I'm the owner and managing partner of my law firm, Your Honor. I provided the affidavit of attorney's fees and my invoice to the parties and the courts in September and again in January of 2024, Your Honor. And so I am requesting at this time that my client be awarded an attorney's fees, Your Honor, in the amount of $34,664.38, which is the amount of.
One more time.
Yes, Your Honor, $34,664.38. And that is for attorney's fees up until January 22nd, Your Honor. And so there may be an additional roughly around $2,500 after today's court hearing. And so we are also requesting that Mr. Gibson's request for a downward deviation be denied at this time, Your Honor. I believe that all the evidence that was presented on January 22nd of 2024 supports this assertion and these claims that are being made today, Your Honor. Thank you.
All right, Ms. Tyler.
Morning, Judge. Natalie Tyler for Mr. Gibson. Judge, the evidence at trial has shown that since the entry of the final order in 2019, mother has had an increase in her income and father has been laid off from his job as of the fall of 2022. Since he was laid off in the fall of 22, Mr. Gibson testified and supplied evidence that he has applied to over 190 jobs, none of which have resulted in an offer. He testified that he's worked with 6 different recruiters and continues to be diligent in his job search. Ms. Fowler is trying to create the narrative that Mr. Gibson is strategically unemployed, but that argument fails. Mr. Gibson testified he was given notice that his position with Newsella was being phased out on September 15th of 2022, and Ms. Fowler did not file this action until October 27th, 2022. How could he have known he was going that over a little over a month after his position was phased out that Ms. Fowler was going to file for a child support modification? Sure, he could go find work at a low-level job earning $50,000 a year, but he's waiting for a position that is more in line with his previous position so that he has the ability to provide more support than he could provide on a $50,000 salary. He testified that the pool of opportunities for a sales leadership position, similar to what he was previously employed doing, is much smaller than other opportunities making less money. Couple this with Mr. Gibson's age, 55 years old, and his ethnic background, that pool gets smaller and smaller. What's more is Mr. Gibson testified to and entered his 2023 W-2 into evidence, which included $230,000 from bonuses that were paid out from his employment in 2022. Despite not being employed, Mr. Gibson is willing to and has imputed himself a $230,000 salary in his proposed child support worksheet and child support addendum. Ms. Fowler's position is that Mr. Gibson is voluntarily underemployed. However, that argument fails given Mr. Gibson's willingness to impute himself a $230,000 salary when he is not working and when he has no guarantee that he will ever receive a job making that much money. Based on his child support worksheet, imputing himself a base salary of $230,000 and using Miss Fowler's $210,000 salary and her paying for the boy's health insurance at the rate of about $278 per month, Mr. Gibson is asking to modify his child support obligation to be $1,746 a month.
Sorry, hold on one second.
That's okay, Greg. Mr. Gibson is asking Your Honor to order that he pay his pro rata share of 50% of the children's out-of-pocket medical expenses.
What was the attorney the amount for child support?
$1,746. And as to out-of-pocket medical expenses, he's asking for a 50-50 split on that.
46, just wondering, does that consider the high income deviation?
It does not. We did not include a deviation.
Okay, so you're saying he imputing himself how much to?
$230,000.
Okay, because that's $1,916 a month, right? And I think that's 16.
I'm sorry, I'm not following what you're asking.
Never mind. You can proceed. Okay, you can proceed.
Okay. And I do have a copy of our worksheet that I'm planning to provide to the court as well, so you can review it.
Yes.
As to work-related childcare, Mr. Gibson is asking that Your Honor remove work-related childcare from the worksheet as that amount fluctuates and will continue to fluctuate. It should be noted by the court that Ms. Fowler's financial affidavit expenses were grossly inflated in some instances. Ms. Fowler testified that while she listed the amount of $2,046 a month on her financial affidavit that she filed with the court on January 18th, 2024, she was actually no longer employing an au pair and did not incur that expense. Mr. Gibson realizes that the work-related childcare can fluctuate, though, and is therefore asking that he pay 50% of any work-related childcare that Ms. Fowler incurs. He's asking for a cap of $1,023 a month, which is 50% of what she listed the cost of the au pair that she was previously incurring.
Say that one more time.
He's asking for a cap of $1,023 a month, which is half of the cost of what she listed the au pair cost that she was previously incurring on her financial affidavit.
Okay.
In addition to an upward modification of support, Ms. Fowler is asking for an order from this court obligating Mr. Gibson to pay for private school. And she's alleging that the children have needs that cannot be catered to outside of a private school setting. Ms. Fowler has not proved the need for private school. She has not presented evidence from any doctors, teachers, counselors, or other specialists actually attending to the children on a regular basis. Rather, she presented testimony from Ms. Fleckenstein, who testified she does not actually work with the children directly on a weekly basis like her colleague Alexandra Hoke does. And she's only seen the children a handful of times versus her colleague Ms. Hoke. I would ask the court to consider, why did Ms. Fowler not present testimony from Ms. Hoke, who is actually seeing the children on a weekly basis and is the professional actually providing updates to the parents on a regular basis? The kids are only 5 years old. They both had several evaluations and assessments, none of which have resulted in a diagnosis of autism or dyslexia. The kids were recently diagnosed with ADHD. However, Ms. Fowler testified that there are services available for the kids in DeKalb County school system, including special education classrooms, IEPs, and 504 plans. The DeKalb County public school system has a process in place for special needs and can handle such needs perfectly fine. Here's an analogy, Judge. We have professional athletes who make tons of money, and then one day they're out of the league. Here, Mr. Gibson made a $1.2 million pay from a combination of his salary, which was approximately $300,000, plus bonuses in 2022, but then he was suddenly let go. If you were making $1.2 million today, private school would be a different story. But he's simply not and does not expect to reach that level of income ever again. In this scenario, not everyone gets to go to private school. If Ms. Fowler wants to continue to have the kids in private school, that's certainly her prerogative, but Mr. Gibson simply does not have the ability to pay for it. And we would ask that the agreement that the parties made in 2019 in their child support addendum, specifically that mom cannot obligate dad to pay for private school, remains in full force and effect. In the event the court does find that Mr. Gibson is obligated to pay for private school expenses, we would ask that he be ordered to pay no more than 50% of the cost, with a cap of $1,916 per month, which is half of the lowest cost private school Ms. Fowler presented as an option for the minor children. He simply cannot afford to pay more than this. He testified that he has in the past voluntarily paid more than what the court has obligated him to pay, including $6,000 towards artificial turf in Ms. Fowler's backyard and $1,800 to fix her furnace in 2022. He further testified that he will continue to make voluntary contributions above and beyond what he's ordered, should he have the ability to do so. Again, I do have a proposed child support worksheet and child support addendum for your honor's consideration, which I can email to Ms. Marshall. What Ms. Fowler is asking for today, Judge, is $4,794 a month in child support, with her worksheet giving Mr. Gibson an $85,156 gross monthly income. This equates to $1,021,867 a year, and including an income for herself of $200,000 a year, when she testified she actually earns $210,000 a year, and her pay stubs evidence the same. She included a $2,000 upward deviation, which is inappropriate and not warranted. Further, Judge, per her child support addendum, she's asking for Mr. Gibson to pay for 65% of work-related child care, with a cap listed of $2,500. Plus, she's asking for Mr. Gibson to pay 65% of private school with no cap, and based on the highest cost private school she presented, his portion would be, at the high end, $4,225 a month. So in total, Judge, Ms. Fowler is asking for an all-in support amount of $11,519 per month, or $138,000 a year. In order to generate enough income to support this obligation, Judge, Mr. Gibson would have to gross at least $200,000. And if he does obtain a job making $200,000 a year, that would leave absolutely no budget for any of his own personal expenses. What Ms. Fowler is asking for is unreasonable. She's made attempts at every opportunity to inflate or deflate certain figures to suit her request. One, she testified her income is $200,000 when in reality it's $210,000. She testified she does not presently have an au pair when she listed close to $2,000 a month in au pair expenses on her financial affidavit. And most concerningly, on her demonstrative exhibit P9, she lists out the expenses she and Mr. Gibson both incurred for the kids in 2023, but she failed to include Mr. Gibson's payment of $1,584 a month in child support, or close to $20,000 over the course of the year, again in an attempt to grossly manipulate the actual support that Mr. Gibson has paid to her. Lastly, Judge, as to attorney's fees, Ms. Fowler is asking for over $36,000 in fees pursuant to OCGA 19615 and 1993. As to 1993, as Your Honor knows, this is a discretionary statute as to custody and parenting time. And as Your Honor recalls, those issues were not before the court today or in the hearing in January, as the parties easily resolved these matters in mediation. Finally, Judge, as to 19615, the court may award fees as justice may require to the prevailing party. Here, Mr. Gibson is asking for a decrease in his total support obligation based on Ms. Fowler's income increasing since the 2019 order was entered and Mr. Gibson's income decreasing. While 19615 also allows for the award of fees based on the non-custodial parent's failure to be available to exercise visitation, Ms. Fowler's position in this case is outlandish. She's imputed Mr. Gibson a gross monthly income of $85,000 per month that he is not earning, and she's asking for an additional upward deviation of $2,000 a month in support based on her proposed child support worksheet. She's mentioned several times that Mr. Gibson has a net worth of over $1.2 million, but such a high deviation is quite frankly absurd, Judge, in no way reflective of extra costs Ms. Fowler incurs by way of Mr. Gibson not exercising all of his court-ordered visitation. Further, Judge, Ms. Fowler's net worth is higher than Mr. Gibson's at a little over $1.5 million per her financial affidavit. Mr. Gibson's net worth is closer to $1.1 million. He spent just under $25,000 in his own attorney's fees, and Ms. Fowler is more than capable of paying her own attorney's fees and expenses of litigation. Thank you, Judge.
All right, thank you. Okay. So just kind of going back through some of the notes before making a decision in the case, I just find myself not just on this occasion, but other occasions being stuck on the amount of involvement that Mr. Gibson has with the children. It's kind of flabbergasting to say the least. I have down here that I have, I think, 6 visits total in over 5 years. Mr. Gibson has a considerable income during those periods of time where he could have flown in, visit the boys, flown them there, just a variety of ways to interact with his children, and he has chosen not to. And there isn't any reason for it but lack of interest. That's what it appears to the court. Just lack of interest. The idea that he's somehow afraid of Miss Fowler but never mentioning it, recognizing that not doing so would prevent him from seeing his sons so that something could be crafted, and he is waiting for someone else to save his relationship, for which he doesn't let anyone know that he has an issue. I don't know what to say about that. I don't know what to say. And then you have your children with some special needs, and you have professionals indicating what those special needs are, there is nothing that's been presented to the contrary, and you're fighting over it. These are your children's educational needs. And it amazes me that someone in this financial position would want to even take a chance. I'm baffled. So what I know for certain is that the children will go to a private school. I know for certain. What I know for certain is that because Mr. Gibson will not visit these children, has not even indicated an inclination really to do so. I don't believe he will. I will also give childcare outside of the deviation. I really just kind of think it's sad. I wish it wasn't that way, Mr. Gibson, and I really wish you would reconsider your actions, because I don't know if you're not understanding, you're not comprehending, you don't care, really don't know what it is. But it really is sad that you have boys that you haven't seen. You only seen 5 times in their, 6 times in their their short lives. I don't understand what could stand in the way of you wanting to see and being a part of your children's lives. I need to look at the numbers with regard to the deviation and the child support worksheet, so I'll take a look at those numbers. I do agree with Ms. Tyler's sum that the 1.2 million for this year probably is high in consideration. He's only made that 1.2 million once over the last 5 years, but I do clearly think that 230 underrepresents his abilities. And I'm looking at it over a 5-year period, which are the numbers that were given. I want these children to have an ability to thrive, and their parents are in a financial position to make sure that happens, because that would be in their best interest. So I need to look at the numbers as to what that will look like. So I'm not prepared to make an actual number on the child support right now, but I do agree that that it is higher than what he's representing, and I do believe an upward deviation is warranted. I have another notation in my notes that also bothers me. And I don't remember there being anything contrary to this, where I think there was testimony that these children don't even receive gifts. Like, they don't get gifts. I don't know how much more crueler you can be to make $1.2 million 1 year and not send a gift to your kids. It's disheartening. And quite frankly, Mr. Gibson, you should be ashamed. Whether you are or not, I don't know. I wish I could understand. I wish I could understand what would make you respond the way you have so that I could fix it. So that I could fix it and so that you would be in these boys' lives. I wish that I knew what it was so that I could give it to you, so that they could see you participate and be a part of your life. I don't think anyone could make me so angry that my children would not be a priority. So I'm going to take a look. I need to look at the DERFA, both of the DERFAs. I need to look at the proposed child support worksheets for both of you. I'm going to ask, I know you probably have it in Dropbox. I'm just going to ask each of you to send over to Ms. Marshall again, separately, your DERFA and your child support worksheets that you are proposing. Send those over to me again, so I can take a look at those. I will award attorney's fees, but I will take a look at the numbers as well in this case. And also, Ms. Hinkson, if you would send me that exhibit with there were various schools on there and the cost for those schools, if you'll send that to me as well.
Yeah, sure.
Thank you very much. I'll make the decision shortly. Likely what I'll do is I'll summarize my findings and I'll ask you, Ms. Hinkson, to prepare to put it in order format. Thank you so much. Y'all are free to leave.